Vinaka, Fiji, and welcome to Speak Your Mind. This week we are talking about an issue that's become the hot topic, not just in Fiji, but internationally. If you're at home, you can call us up 3220-906 or 3220-907. The topic today is, of course, the release of Fiji's constitution. If you have any questions, if you have any clarifications or need any clarifications, now is the time to call, because who better to have to answer your questions than the Attorney General himself, Mr. Aiyaz Sayed-Khaiyum. Sir, welcome to the show, and thank you for taking out time for Speak Your Mind.
Thank you for having us. Thank you.
Let's just jump right into it, Mr. Sayed-Khaiyum. Very briefly, I know there's been a lot said about the Constitution over the past week, over the weekend. Just very briefly on the Constitution itself, just a brief summary.
Well, Roland, thank you for that. I mean, essentially, this Constitution that has been put out essentially is a amendment to the draft that was put out. As you know, that following the publication of the draft Constitution, we went throughout Fiji, to various parts of Fiji, and indeed, as the Prime Minister highlighted, that he himself and all the other ministers, wherever they went in respect of their, travels throughout Fiji regarding their work, they also had received feedback from people from different corners of Fiji, and we had widespread consultations on that. And following the receipt of that verbal feedback that we got, we also received over 1,000 written submissions, either by way of text, by way of emails, by way of actual written submissions. Some of the submissions were very good. Some of it cleared up some of the technical aspects of it, but also some of the issues that were also highlighted, which have been incorporated, has been the specific mention of various areas that people thought that needed to be addressed and elucidated quite clearly. So, for example, if I can take you to the preamble of the Constitution, whilst
just before you do that, sir, you mentioned about the different submissions and the amount of submissions they received. It's quite safe to say that the whole of Fiji has had their say in this Constitution.
We believe so. I mean, I think the fact that, as we said, that the submissions were received also whilst the Prime Minister and his ministerial team were going out in their respective work. And also then we had the formal consultations where we went to about 19 different locations throughout Fiji, and then had feedback where we actually explained the constitutions, and people were, in fact, had the opportunity to ask any questions and make submissions on anything. There was no restriction whatsoever on it. So after all of that, and then the receipt of the written submissions, this final constitution has been put together. So, for example, if you go to the preamble, in the draft there was no specific mention of the recognition of the different groups in Fiji. And indeed, for example, we had received some strong submissions, for example, people from Rotuma, who said that there's no mention of Rotuma whatsoever, and the Rotuman people who had decided to make Rotuma part of Fiji. So if you look at the preamble, it says, "We, the people of Fiji, recognizing the indigenous of the Itauke, the ownership of the Itauke lands, their unique culture, customs, traditions, and language." Now, similar provision is provided for the people from Rotuma, and again, the unique culture, customs, tradition, language. Because, they're indigenous to Fiji, and obviously these customs and traditions and practices and language are only carried out in Fiji. So we need to recognize that, and the primacy of the indigenous people in terms of them being the first peoples to Fiji. There is a recognition of that. And of course we recognize the descendants of the indentured laborers, both from British India at that time, which it was, and also the people from the other Pacific Islands, who also need to be recognized for that. And indeed, it's a contribution. And also then the recognizing the descendants of the immigrants and settlers to Fiji. And then the rest of the preamble is exactly as we had previously, saying we declare that we're all Fijians, united by common and equal citizenry. So we recognize the uniqueness of the indigenous people, and then the other groups that came to Fiji subsequently, and then saying, however, in the modern nation state of Fiji, we're all united by common and equal citizenry, and then the values that are enunciated.
We're all Fijians.
Absolutely. And there is also a provision for that says that we're all Fijians. I mean, unfortunately, I suppose, given our history, we have to specifically mention it, whereas other countries, they take it for granted. That if you're from Australia, you'll be an Australian irrespective of background. The other important aspect I think a lot of people are concerned about is the supremacy of the Constitution, which is in Chapter 2, which basically states that the Constitution is supreme law of the land, and that it has to be respected by all Fijians and the state, including all persons holding public office. And then the Constitution must be enforced through the court system and more specifically, Constitution cannot be abrogated or suspended by any person and may only be amended in accordance with the procedures that are prescribed in this Constitution.
That was actually leading up to one of my next follow-up questions, Mr. Sayed-Khaiyum. A lot was said before the release of the Constitution and while submissions were being made that this Constitution will put an end to the so-called coup culture that Fiji was becoming known for. This is the answer to it?
Well, I mean, this is one of the provisions that lead to that. I mean, as we all know, that the coup culture, so to speak, it can be stopped not only just by one sentence that's been put in the Constitution, but also other practical implementation of other policies. For example, if you go out throughout Fiji with submissions that were received through the consultations we had, even if you look at the Guy Commission that went out and various other feedback through other means, people essentially are concerned about everyday issues. And when those fundamental issues aren't addressed by governments, then it does create disquiet. When, for example, the fundamental safeguards that we put in and recognitions that we put in, if they aren't there, then there is disquiet. But more so than that, you need to have accountable mechanisms built into the Constitution. So we can discuss this later on as to how we have a code of conduct for public office holders in terms of them having to declare their assets and liabilities because it minimizes corruption. In the same way with the electoral system, if you have an electoral system that is truly reflective of the will of the people, then people will feel a sense of ownership in the government that's elected. So with proportional representation, the percentage of votes, putting it simply, that a political party gets, that's the proportion of seats they'll get in parliament. I mean, if you talk to political parties like NFP, they will tell you that in previous elections, they received a substantial portion of the votes, but they did not win a single seat because the actual electoral system did not capture that. They don't have the ability to translate the portion of votes they got into seats. This one will do that. So I think when you have people having a buy-in to all these different facets of governance and electoral systems and accountability mechanisms and a constitution that recognizes all those rights, then you have a buy-in and you reduce the coup culture. And then by having specific legal provisions saying you cannot have form of government other than in accordance with this government, I think is really the icing on the cake, so to speak.
Yeah. If you're listening from home, 3220-906 or 3220-907 is the number to call if you have any questions on the Constitution or if you need any clarifications. We'll go to a short break, and when we come back, we'll talk more on the content of Fiji's new Constitution. Welcome back. You on Gold FM's Speak Your Mind. This is our second segment, and we're talking about the Constitution today. Our chief guest is, of course, the Attorney General himself, Mr. Aiyaz Sayed-Khaiyum. Sir, just continuing on from our last segment, you were mentioning something about all citizens of Fiji, known as Fijians now?
Yeah, as I mentioned in the previous segment, that we have a emphatic statement that has been put out that all citizens of Fiji shall be known as Fijians because the country is Fiji, so you call it Fijian. It does not in any way diminish the cultural identity of all the different groups in Fiji. Like all modern day countries.
I think that was one of the initial worries when this first came out. Huh?
Yeah, but that's all the protections are built in, the recognitions are built into it. Like all modern countries, if you're born in Australia, you're an Australian citizen. USA, you're an American. If you're born in France, you're a citizen of France, you're French. And that's taken for granted in those countries. In Fiji, unfortunately, because of politics, we didn't. But that's sort of emphatically stated. So I think that clears up the air. But I think in relation to that also, we probably should talk about the protection of Itaukea land ownership and Rotuman ownership and Banaban land ownership. Yeah. There's a specific provision which is Section 27 of Chapter 2, 28, which talks about it says it's titled Protection of Itaukea, Rotuman and Banaban lands. Yes. Now, this Constitution...
In case you're from home, if you're at home and you have a copy, it's on page 23 of the Constitution?
Yes. And also we have the vernacular version in Itaukea language in the Fiji Sun today.
Yeah.
So you can turn to Section 28, which basically talks about the ownership of all Itaukea land shall remain with the customary owners of that land. and the Itauke land shall not be permanently alienated. In other words, you cannot ever sell it, grant it, transfer it, exchange it to permanently alienate. Permanently alienate means like forever it's gone.
This was possible in the past, before this constitution?
Well, there was a mechanism through which it happened, and we've also gone and closed that gap, which is subsection 2. It says, because previously and now also, if you, for example, if government needs to build a road, so they need to acquire some land, they need to go to the landowner, whether it's freehold or whether it's Itauke, they can go to them and say, look, we need this for public purpose. Section 27 allows them to do that, as with other previous constitutions. For public purpose, you can say, we'll pay you fair compensation because we need to build a 4-lane road here. Now, previously, when Itauke land was converted to state land, it basically sat in the state land pool. But there was also another provision in the law that said that state land can be converted to freehold land.
Okay.
So that's how some Itauke land got alienated permanently by being converted from Itauke to state and then from state to freehold. What subsection 2 says, you can't do that anymore. The Prime Minister had already put in place a law earlier this year, but we've now actually put it into the Constitution. That is, if Itauke land is used for state purposes, like you're building a road, and they built a road, after 10 years, 15 years, 20 years, whatever it may be, if the state no longer requires that Itauke land for public purposes, it must give it back to the Itauke landowners. So there is that additional protection that's been built in. It's given a constitutional teeth now. Previously, that protection was not there. Now, we've done a similar provision for Rotuman lands and a similar provision for Barnaban lands.
Were there also submissions made in this regard?
Yes, in the draft we had said that the original Section 27 gave that the protection, and there were additional laws that gave it the protection. But there was a sense that people wanted it specifically stated in the Constitution. So, and especially enunciated because of, I suppose, again, our politics. So that's been specifically now included in the Constitution itself. So all those people who may have felt that it was not quite there and needed to see it with their own eyes, it's there now. And now the additional benefit now that's under this Constitution, which has not been given ever before, and indeed it is very rare in the Commonwealth also. We inherited a legal system from the British that basically said that if there is anything below 6 feet, on the ground, belongs to the state, belongs to the government. So therefore, if there's some gold found on some Itauke land, or even freehold land for that matter, but 91% of all the land in Fiji is Itauke land now. If, for example, gold is found 6 feet below the earth, now the Constitution says that any royalties that the state gets, the ownership still rests with the state, but any ownership that any royalties that the state gets must be shared fairly. Must be shared fairly with the landowners. So that's an additional benefit, and indeed it's a recognition of the fact that they are also the landowners, and that their ownership should not go, or suddenly stop below 6 feet, or at 6 feet, I should say. So that additional, benefit is now been put in. It also extends to the seabed, not just on land. So if it's in the seabed area, wherever there is a claim of customary ownership of that area, and if, for example, they find gas or what have you, the landowners must get a fair share of the royalties, that particular landowning unit. So this is quite, in a way, revolutionary in terms of how the law has been amended through this Constitution to give landowners that fair share.
I was actually just gonna say something along those lines, Mr. Sayed-Khaiyum. So I know it's only just been a few days since the release of the Constitution, but have there been any feedback so far?
Definitely. I mean, there's a lot of people who are saying, and I think you see it in the press, although I know the letters to the editor are controlled by the editors of the respective newspapers. But notwithstanding that, I think all the feedback that we've received has been very positive. In particular, the recognition, in particular, the protections, the specific protections that have been built in. And you see and also, of course, the extraction of minerals. The wonderful thing about putting it in the Bill of Rights is that it's not confined to one particular law. Like previously in the 1997 Constitution, that of Native Lands Trust Act, you could not amend it. So even if you have to change a full stop, you have to get all the 2/3 majority. Of course, in this one, it has to ensure that all laws reflect these rights. All laws must reflect these rights that are guaranteed. Not just land laws, but any law must value and cherish and indeed protect these rights that are enshrined in the Bill of Rights.
I'm pretty sure landowners have really welcomed this, Mr. Sayed-Khaiyum. If you're at home, 3220-906 or 3220-907 is the number to call. You can email us on goldfm@fbc.com.fj for any questions or clarifications on the Constitution. Mr. Sayed-Khaiyum, if we can just divert our attention to the, let's talk about elections, constituency. Why don't you just explain to us how this works? We have one constituent now?
Yes. For example, the two specific amendments have been made compared to the draft. And one of them is, for example, in the draft we had 45-seat parliament. It's now been increased to 50. We had some submissions on that. And also now, if you'll see in the Constitution, there's a specific mention that there must be a committee system within Parliament. So, Parliament breaks up for different committees.
So if I can just stop you there for a second, I think we have a call online. Good afternoon, you're on Gold FM, speak your mind.
Good afternoon. Excuse my voice.
Yes, your question, please.
But anyway, number one is to thank the government of the day, Ben Marama, and all the hard-working members for putting up this wonderful constitution for Fiji. And secondly, our group is member of the many submission to the Constitution during the government open submission to the public in early, I think April this year. We were one of them, and we must thank the AG, Mr. AG, for clearly stated the rights of the indigenous Tukey. That was our main concern. And of course, the Rutumans and the Banaman.
Right. I'm sorry, I'll just have to...
Thank you very much.
Okay, thank you very much for that.
Thank you.
Well, there you go, Mr. Sayed-Khaiyum, another happy citizen.
Sorry, just in
Carry on.
In respect of the other sort of key areas, we have also, as you just in that vein, we have the equality provision in the Constitution. The equality provision in the Constitution basically says that everyone has the right to equality and freedom from discrimination, unfair discrimination, and you cannot be, discriminated against on various grounds. And we've in fact made that quite large. So you cannot unfairly discriminate against a person on the basis of their culture, whether they're pregnant, whether they're married, expression, conscience, their sex, gender, etc. All those exceptions, all those grounds have been put there. Now, what the other interesting thing is also, this Constitution says those unfair discrimination provisions also relates to the private sector now. Previously, there were some exceptions that, it stops in the private sphere. So what it's saying now, it's in legal speak, is available both horizontally and vertically application of those rights. They are, however, so do you go for a break?
Mr. Sayed-Khaiyum, there's so much to say. I think we might have to bring you back for another show next week, but we'll go to a break now and we'll talk more on the Constitution when we come back. Pulavinaka, Fiji, if you've just joined us, this is Gold FM's Speak Your Mind. Our discussions today, the topic is, of course, Fiji's new constitution that was released only last week. In studio, we have with us the Attorney General, Aiyaz Sayed-Khaiyum. So if you have any questions or if you have any comments, feel free to call us up 3220-906 or 3220-907. Mr. Sayed-Khaiyum, you're talking about equality?
Yes, about, unfair discrimination.
Yeah.
So, for example, we've now expanded it, so people cannot discriminate against you on those various grounds. Now it's quite enlarged. And now also specifically, like I was saying, it applies to the private sector also. In fact, we addressed this with the CPA on the weekend. We had a meeting of all these accountants and told them they need to be cognizant of this too. There are, of course, certain restrictions on these unfair discrimination provisions. So we've said, for example, the law of marriage, for example, will prevail. The law of marriage in Fiji is the union between a man and a woman. So we cannot discriminate. To talk about the elephant in the room, let's talk about these things openly.
Yes.
The law basically says, as it stands, we cannot discriminate against people who are homosexuals. And many people, I think most people in Fiji will say, yes, we do not want to discriminate against them. They are friends, they are family members, they are work colleagues, the people we know. And they should be given equal access to all, public amenities, private amenities. We should not discriminate them on the basis of their sexual orientation, in terms of employment, etc., medical services, all those sorts of things. But what it says at the same time, that the law of marriage shall be a union between a man and a woman. So a person who is homosexual cannot come and say that because there's unfair discrimination provisions there, that I need to be married, or you should allow me the right to get married. What this says is, because the general view in Fiji is that whilst people don't discriminate against homosexuals or don't want to, it doesn't mean that extends to giving them the right to get married to each other in a homosexual relationship.
So if I can just stop you very quickly, I think we have another call on the line. And that person just left. Yes, carry on.
And the other one is that we've also said that to the extent that it is necessary, there may be laws that will be developed to give effect to the communal ownership of Itauke, Rotuman and Bandaban land and access to marine resources, and also the bestowing of Itauke, Rotuman and Bandaban chiefly title or rank. So again, that's to give protection to those customary practices. So if you give or allow for those customary practices, then it gives them protection in the sense that no one can come along and say you are unfairly discriminating against me. For example, there are certain landowning units where the chiefly title can only be given to males. So what this basically says is that customary practice can continue because it's part and parcel of their custom. In the same way, for example, there are certain landowning units that they may, divide their land in a particular manner. So nobody can from within the landowning unit come and say, oh, why did you give this land to the Vasu or whatever it is? So it gives that protection to the customary owners. And so I think that's quite clearly enunciated in that. The right to education includes a new provision, of course, apart from the fact that all governments have to ensure there needs to be a right to free education up to tertiary level, the progressive realization of that. We now say that conversational and contemporary Itauke and Fiji Hindi languages must be made compulsory in primary school levels. And there's a lot of submissions on that. People, I think
FBC had
made a submission on that to create.
Very proud to be part of it.
Yeah, so people can able to converse in the two major vernaculars. It also does encourage or gives more people to be able to speak Itauke language also. So, is one way of also protecting the language from actually disintegrating or being waned down or watered down through other languages coming in. We had talked about before the break about the electoral system.
Yes,
so we have a 50 seat.
I think there might be a bit of confusion. People may be confused a bit on this. So we were just wanting you to just explain how this works.
Sure, it's we now have 50 seats in Parliament as opposed to the 45. We have one house, don't have a Senate. For example, New Zealand has only one house. And it's proportional representation, as I mentioned before. So the amount of seats that a political party gets in Parliament is proportional to the percentage of votes they win. So put it very simply, if a political party wins 30% of the votes, they get 30% of 50 seats. Right. So they'll get 15 seats in Parliament. That's how it works.
So if I can just ask, Mr. Sayed-Khaiyum, if I go and vote myself, who am I voting for? How will I know?
And then because proportional representation in an open list system, a political party can obviously field up to 50 candidates. So the way that we are considering in terms of the actual ballot, the voting systems and all, the papers will tell you about that later on. But at the moment, there's an idea. You have a board up there when you go into in the polling booth. You basically just give one vote. You choose whoever you want. Now, obviously, that person comes from a political party. So when they count the individual votes, they also then tally it across the political party itself. So you may have, say, for example, 10 people in one political party that may win, 5% of votes each. So when you add up as to how many seats the political party should get, they add up all the votes they've got all together, and then they proportion the seats accordingly. So that's how it works.
Okay.
And obviously there'll be massive voter education on that. Now this system is also used in
my follow-up question.
Massive voter education on this. But it's a lot fairer system, and we have a single constituency. In other words, there's no, as we had Lao open, Ba open, whatever it may be.
The question might arise there, Mr. Sayed-Khaiyum, is someone may say, in the old constitution we had our rep, representing us. how will our voices be heard in Parliament
Sure.
with this one constituency?
All 50 of them will be a rep. And I think that's the best way to describe it. Because previously you had only one person. The person can't be found, or they're spending too much time in Suva, in a nightclub, or whatever it is. You can't get to that person. Now every single member of Parliament will be your rep. And what it also means that every single member of Parliament will now have to appeal to everybody. Before, if I was, for example, voted in from Lautoka open, I really did not care about what was happening in Vanuatu. Now, if you're a member and you've originally come from Lautoka, you live in Lautoka and you voted in, you have to be concerned about what's happening in Dikumbia. Your political party needs to ensure that its policies are all geared towards everybody in Fiji, not just one section. You know, we had, for example, previously political parties coming up along the lines of one area of Fiji, one community of Fiji, one province of Fiji. Now they have to appeal to everybody. So in this way, it creates political parties or forces them to build national policies that addresses everybody across the board in all areas of Fiji. Because as you know, certain areas in Fiji are underdeveloped. The politicians and the political parties will be forced to think about all the areas. Israel uses this. Netherlands uses this. There are other countries, but these are the two larger countries that have a single member constituent or single constituency. The entire country is one constituency.
And are we still looking towards having elections or in just one day?
Yes, that is one thing that we want to be focused on. Indonesia, for example, to give an example, has about 110 million voters. They have 10,000 islands on which they live on. They have elections, in fact, within 5 hours. So it can be done, and we've already sort of spoken to people from the Indonesian embassy. We've met one of the electoral commissioners also. And the idea is to bring in all the good skill sets. We've obviously spoken to the developing partners that want to help us. Commonwealth, EU, Australia, New Zealand, USA, India, China, France, all these countries have come to the party, and of course not forgetting Papua New Guinea.
Like I said earlier, Mr. Sayed-Khaiyum, I think we might have to bring you back for another show on Speak Your Mind. We're running out of time. 2 more segments to go. If you have any questions or queries, 3220-906 or 907 is the number to call. When we get back, we'll talk more about the Constitution. Welcome back. You're on Gold FM's Speak Your Mind. The topic today is the Constitution. We've said so much already, but there's still so much to be said. And like I said earlier, we might have to get the Attorney General back if he's free next Monday. Mr. Sayed-Khaiyum, I understand there's also provisions for protection for tenants in the Constitution.
Absolutely. I mean, essentially, there are 3 specific provisions. One, it says that all interests in land, including tenancies that exist the commencement of this Constitution, will continue. And no Parliament can make any laws that will in any way undermine any tenancy agreement you may have. So, for example, if you're leasing a land from Itauke Land Trust Board, and it's a 50-year lease or 70-year lease or 99-year lease, you are governed by the tenancy agreement. So, in 2014, 2015, no Parliament can come along and say, we're going to take away this tenancy. Your tenancy is protected, given constitutional protection. And you need to abide by the tenancy agreement. So, of course, under for example, the Itauke Lands Trust Board tenancy agreement, you may need to pay lease every year, you pay a premium, whatever it may be. You need to abide by that. Of course, if you don't pay your lease, then they have the right to seek recourse against you. But fundamentally, no Parliament, no government can ever take away any of the rights that are enshrined in the tenancy agreement, which you enter in at your own will. And secondly, it also talks about the protection of freehold land, that all freehold land is protected, of course. But, if you want to sell it, it's up to you. You want to sell it to the state, you want to sell it to Itauke landowners, that's your choice. But your actual rights, as far as the title is concerned, is also protected. So I think it's very important to have that provision quite specifically stated in the Constitution, as opposed to the 1997 Constitution that just referred to, for example, protection of Itauke lands, only the actual act itself. It was not specifically stated in the Constitution. Similarly with the tenancy, it just referred to ALTA. This is now actually within the Constitution. It's important to have these provisions because, as we mentioned, that nearly 91% of all the land in Fiji is Itauke land, then about 4 or 5% of crown land, and then the balance is freehold land. So most people in Fiji will either lease land or be, a subtenant of somebody who's leased land. So those protections are equally important.
Remember, if you're at home, 3220-906 or 3220-907 is the number to call if you have any questions regarding the Constitution, or if you have any comments to make. You can call us up and, of course, pose your question to the Attorney General, Mr. Aiyaz Sayed-Khaiyum. Mr. Sayed-Khaiyum, moving on. I know there's so much to talk about in the Constitution, but looking at the code of conduct that you mentioned earlier for public office holders,
Yes.
what can you give us shed a bit of light on this also?
Sure. Essentially, I mean, for the first time, we have sort of in more detailed said there needs to be a code of conduct for public office holders. In other words, all public office holders, which includes the President, the Prime Minister, the ministers, the senior civil servants, they need to essentially adhere to a code of conduct. And more than that, they now also have to declare their assets and liabilities. And they need to make that available to the Accountability and Transparency Commission. We've never had such a commission before. This commission will be independent, completely independent, and it must, for example, monitor and be the office where all public office holders go and give all the details. Once a year, give all the details. So, you can then walk in and find out how much money I earn, what assets I have, what my spouse has.
So this is all for transparency, Mr.
Absolutely, because obviously, if I'm a minister and I'm got $100,000 in my bank account, and then next year you come along and I've got $2 million, and we don't know how it came about, obviously it must be done through illegal means. And the Accountability and Transparency Commission has the ability to investigate and, of course, refer it to FICAC. So it's setting new standards of public accountability. So the public must be aware as to what is the financial status of somebody? How did they acquire that wealth? Because the rationale behind all of this is that if you want to join public life, you need to make certain aspects of your private life public. You have to do that because it's a particular standard of behavior that's expected of you. And of course, also because you are in charge of public funds, you need to be, we need to know what you're earning personally, what your assets and liabilities are. The Accountability and Transparency Commission also has specific provision to protect whistleblowers. There are a lot of people, for example, who may know of things, but there's no actual constitutional provision for them to be protected. And so there's specific provisions for that. In respect of the actual code of conduct, the law itself, we hope to have that in place by the end of the year. So we'll have that even before Parliament sits.
And as for the commission itself, who appoints the commission?
The commission is appointed, the members of the commission are appointed by the Constitutional Officers Commission. The Constitutional Officers Commission consists of the Prime Minister, the Leader of Opposition, the Attorney General, 2 independent nominees of the Prime Minister, or outside government I should say, and 1 nominee of the Leader of Opposition. And you'll see in the provisions regarding the membership, we've gone to great lengths to say that once a person is appointed to that commission, you cannot remove them. Of course, the office holders, leaders of opposition, prime ministers, and attorney generals come and go. But as far as those people who are appointed to it, they're appointed for a specific term. You can't remove them. Just because they make a decision, you can't remove them. If there is a cause for removal, you have to go through a tribunal system. And the other thing, Roland, that we've done is, as in the 1997 Constitution, for example, you could, if you thought that the President or the Chief Justice had engaged in behavior that was unbecoming of those 2 offices, or they were, ill mentally, etc. It may be if they were ill, they became, for example, senile, you put in place a medical board because they refused to resign, etc. And then a decision was made on that. But there was no provision in the 1997 Constitution to say that you had to make that report public. This Constitution says you have to make the report public. So you and I and everybody else in Fiji will know this is what the report says, whether it's a medical report or whether it's a disciplinary board report. And the president or whoever it is that's going to make the decision has to follow the recommendations of the report. They don't have a choice. So firstly, we are saying you can't willy-nilly just, accuse somebody or remove somebody. If you do, there's a higher standard. You have to go through a tribunal process. Right. The report must be made public, and then also the report or the recommendation in the report must be made public also. So there's all these mechanisms that are built in within this Constitution that creates a lot of transparency, not just by having FICAC, not just by having the Independent Legal Services Commission, but it also creates various methodologies, within the actual application of those laws, or the application of the functioning of those commissions, completely transparent.
Right. Mr. Sayed-Khaiyum, understand we are also looking towards elections before the 30th of September next year.
By
By September 30th. What happens to all the decrees that are currently in place right now?
Sure. There is a transitional provision in this constitution that basically says that all the decrees that have been put in place will continue to apply. And indeed, the validity of those decrees cannot be challenged. But once Parliament sits, the new Parliament can do as it wills, under the under the confines of the Constitution, of course.
Right.
But as far as the decrees are concerned, they can completely get rid of a decree. They can amend a decree. They can repeal a decree. They can build upon a decree. That's the prerogative. And the reason why it's the prerogative is because all Fijians would have voted for that government. So, for example, the Bainimarama government has put in place the domestic violence decree. So the new parliament may come along and say, we don't need domestic violence decree. Let's get rid of it. They can do that. But they cannot go back in time. So, for example, if a person has been sentenced to prison under the domestic violence decree today, or this year, or before the first sitting of parliament, they can't go back and say, just because we got rid of it now, post 30 September 2014, let's pay this guy compensation. Or, because we sent him to prison. They can't do that. You can't challenge any of those decisions, because that's to give certainty. Otherwise, you're going to open up a whole Pandora's box. And, we'll have a very, very litigious period.
That's true. Thank you, Mr. Sayed-Khaiyum. I'll have to stop you there again. We're running out of time. When we come back, we'll have our last segment of Speak Your Mind, more talk on the Constitution. Welcome back to Speak Your Mind. This is the last segment. We're talking about the Constitution that was released last week. In studio with us is the Attorney General Aiyaz Sayed-Khaiyum. So, Mr. Sayed-Khaiyum, like I mentioned earlier, we might have to bring you back next Monday, of course, if you're free. But just moving on from what we just spoke about, I understand there's also a Judicial Services Commission
Yes.
Established under this Constitution?
Yes, I mean, we had a JSC in the 1997 Constitution, but it was a very small commission. The JSC previously used to be, it consisted of the chairman of the Public Service Commission, the president of the Fiji Law Society, and the Chief Justice. We've now expanded the size of the JSC, and it will consist of the Chief Justice, the president of the Court of Appeal, the permanent secretary for justice, a legal practitioner with no less than 15 years experience, and a person who's not a legal practitioner. In other words, somebody from outside the legal fraternity, perhaps somebody from the NGO, civil society, who, we need to get the public sort of view, people from the non-formal sector, non-judicial sector to have a say in it too. And they're completely independent. For the first time in Fiji's history, there's a specific mention that the judiciary is completely independent, not just in words, but actually in theory, in practice, I should say. That is, they have their own funds. They're given an envelope of funds, and the JSC actually carries out the appointments of people in the judiciary, etc. At the moment, the situation is, as has been previously, if, for example, the Chief Justice tomorrow wants to transfer somebody from the Bar Court Magistrates Court, or court clerk, to the Lautoka Magistrates Court, he can't do it without PSC's permission, or various other position holders. And that has been the position for a long period of time. There has been some changes done, within the civil service overall. But this gives it that complete independence, which is essential. In the same way, the various independent institutions, the Accountability Transparency Commission, JSC, FICAC, the Independent Legal Services Commission, DPP, Solicitor General's Office, the Mercy Commission, Accountability Transparency Commission, they all have a charge on consolidated fund. In other words, Parliament must always make sure that these independent institutions always have enough money so they can function, because they're independent institutions of the state. And this is if you look at this constitution, it's building strong institutions. The problem with Fiji has been that for a very long period of time, we did not have strong independent institutions. been very politicized. Perhaps some would argue more so after 1987. And so it was personalized. Institutions were weak. There was political interference. We need these institutions to be standalone institutions so the public feel confidence in them and they can go out and, for example, lodge their complaints and ask for, investigations, etc. One other point, sir, before I forget, that we received a lot of submissions on was, if you recall in the draft, we had the Prime Minister as the Commander-in-Chief of the RFMF.
Yes.
If you see in this constitution now, it's now the President. The President, as it states, performs the ceremonial function of the Commander-in-Chief. I think one other point also that was we received a lot of submissions on and people felt very strongly about it was the qualification requirements of people who can stand for Parliament. And for the President too, vis-a-vis criminal convictions. So, there were some people, for example, said you cannot ever stand for Parliament or become the President if you've had an offense, any offense. I mean, you could have a speeding ticket.
Right.
You could be 20 years old and had a speeding ticket. In 50 years' time, you're probably somebody who's very, very good and qualified to be the President or, member of Parliament, but you'll be forever disqualified because there's an offense has been committed. So we've given what you call a stand-down period. So if you have been, in terms of Parliament, as far as the criminal conviction issue is concerned, if you have been somebody who's been convicted for an offense that carries a sentence of 12 months or more, you cannot stand for Parliament for 8 years from the date of your conviction. After 8 years, you can. The reason why we've given 8 years is because it's 2 terms. As you know, the Parliament time now, government is only elected for 4 years now. So and they must have elections within 4 years or 3.5 years, any time between then. And the President's term, of course, we've also said a similar thing. President's term is 3 years, so we've said there's a stand-down period for the President of 6 years, so 2 terms.
Yeah. And I believe the President also is appointed by Parliament.
Yes, I mean the names are nominated by the Prime Minister and the Leader of Opposition,
right.
And then people vote.
Just very quickly, Mr. Sayed-Khaiyum, we're running out of time now. If you can just touch on immunity also,
Yes.
Who comes under immunity in the Constitution?
Sure. Basically, the immunity that was given in the 1990 Constitution for the events of 1987 continues. And then also for those people from the events of 5 December 06, there's immunity given in respect of persons, whether in their official or personal capacity. And this immunity provision cannot ever be removed, as it was in the 1990 Constitution, which flowed through the 1997 Constitution for the events of 1987. So it's consistent in that sense. And that is fundamentally, that is to give stability to the way going forward. However, there is no immunity for the persons listed, which includes the President, Prime Minister, Cabinet Ministers, RFMF, Fiji Police, Fiji Correction, Judiciary, Public Service, and any public office holder. You don't have immunity from things like rape, murder, bribery, corruption, stealing. So there's no immunity for that, and that's what the immunity provision caters for. Now, linked to that, of course, is
right.
The amendment of the Constitution. How can this Constitution be amended? There's a very high threshold. And the amendment is that you of course can't amend the immunity provision, nor can you water it down. But if, for example, somebody wants to amend the Constitution and it's put to Parliament, it must be approved by 3/4 of the 50 members. But that's not it. It then must go to the voters.
Yes.
And the voters, then 3/4 of the voters registered must vote in favor of the amendment that is sought.
There was some talk also that the way the Constitution was set, it cannot be changed. Is this what we're saying? It can be according to these requirements?
Well, all constitutions have a provision for amendments. For example, the 1997 Constitution simply had 2/3 of House of Reps and 2/3 of the Senate, But this Constitution, you actually take it to the public for any amendments that is to be carried out. And that's where people have a say, and that is where we have the additional protections that are built in, because the people actually will have a say in any amendments that is sought, and it's 3/4 of the registered voters. The reason why it's registered voters is because it should not be 3/4 of the people who vote. In, say, 20 years' time, you could have, everybody's having a good time, etc., and there's amendment being sought, and only 100,000 people turn to vote, you could have effectively 75,000 people amending it, which is what we don't want. It's the registered voters.
Right. Like I said earlier, Mr. Sayed-Khaiyum, we're running out of time. So if you're free next Monday, we'd like to have you on the show again, just to speak more on the Constitution. But before we go, just maybe a few words on the critics out there who continue to look down upon the Constitution. Some politicians boycotted, as you are aware of the briefings last week, saying that the process wasn't, what was the word that they used, wasn't, they said that they didn't want to come for it. What do you have to say to them and to the other critics who are tuned in today?
Well, I think, it's not a question of answering the critics. I think I'd like to basically say that if you look at the Constitution, if you want to carry out a true, objective, and truthful assessment of it, you need to come to it with an independent mind. You need to come to it with a apolitical mind, not a political mind. And you'll see, as I highlighted earlier on, this Constitution builds strong institutions. It addresses many fundamental issues that has been politicized. For example, protection of land, access to mineral resources, common equal citizenry, corruption, etc. So those issues are taken care of now in this Constitution. So we can get on with living. We can get on with improving the lives of all citizens of this country. We can get on with the economic growth. How do we help and address issues affecting the poor? There's a very heavy emphasis on socioeconomic rights, as you'll see, which we did not get a chance to discuss.
We will.
Right to education, right to water, sanitation, housing, transportation, economic participation, specific provisions for people with disability, children, etc. So those issues is what we want people to focus on, because as we said, all the feedback people gave, they are the areas they talked about. So the politicians, the older ones, are used to talking about those areas that are so-called unresolved issues. This Constitution resolves that. All those fundamental issues are resolved. So let's get on functioning as one nation, functioning all of us as Fijians, and how to benefit the lives of individual Fijians and our country.
Mr. Sayed-Khaiyum, thank you so much. We will talk again on this next Monday. If you're free, please make time for Speak Your Mind again. But before I go, just one last question. Prime Minister has announced that he will be standing in the next elections. He will be forming a political party. Do you have any plans for next year's elections?
Well, Roland, there's a lot of work to be done in terms of preparations for elections and drafting a lot of rules and laws and regulations, and that's what we are focused on.
Thank you very much, sir. Thank you for your time. That was Speak Your Mind for this week. Remember, next Monday, if the Attorney General is free, we will let you know, and we will have more talk on the Constitution next week, Monday, 12 p.m. on Gold FM, and of course, replays on Tuesday nights, 10:30 on FBC TV. I'm Roland. Bye for now.